Well, item number 2, man. Well, from last night, man, I'm suffering from neck ache, man. Serious neck ache problem, man. Some time maybe alone.
You're suffering from?
Well,
Suffering from
neck ache.
neck ache. Yes, who's for the other side?
PP, man. PP.
Any objection?
No.
Adjournment prayer has been made by Mr. Your name is not here.
Item 2, man.
At item 2. By Mr. P.J. Saikya. Learned Council for the Appellate. Which is not objected. And accordingly praised. Which is not objected to by the this A become addicted to. Accordingly, leave this matter
On 4th, man, if possible.
on 4.
4th of February.
The acquittal is challenging the acquittal.
Yes.
Right. This is an appeal challenging the acquittal of the respondent and from the charge framed under section 304 bracket B slash 302 slash 34 I think.
4th of February. Alright.
I may appeal also. I beg to mention for listing one, I will email appeal. And next to any date. Time for listing IA for benefit lordship promise the after appeal is of 2022 minor.
Huh?
Appeal is of 2022 minor.
Maybe next week.
Minor. This was basically challenging the improvement, sorry, maintenance order passed in a 125 proceedings before the family court. The last occasion, I suggest that since there is a divorce case pending, as well as a guardianship case pending, BV case pending, and as well as this question, let the matter be taken for mediation. My learned friend was asked to open instruction. In the meantime, the last occasion, an order was passed. It was earlier listed before a single bench. Now, if lordship kindly goes through the last order, there are 2 notifications from the High Court, which says, an order against from a family court shall be placed before a special division. There are 2 notifications. The first one is the 21st of March 2023.
Yes, so
The only thing, the confusion which has arisen, the lordship kindly come to the Family Courts Act. Now, lordship will, first of all, lordship will come to section 9(7).
9(7).
So section 7, 7F. Subject to the other provisions of this, family court shall, and lordship, if you come, lordship comes to F.
Yes.
A suit or proceeding for maintenance. So, and lordship will kindly come to 7(2) again.
Shall have and be deemed. Huh? No. Subject to the other provisions of
Okay,
the
so a family court shall-
court shall,
Shall, yes, ma'am.
uh,
Shall exercise powers of in respect of a suit or proceeding for maintenance. And if your lordship kindly comes
just a
to
minute. Shall exercise, where do you read exercise?
family court shall have an access to all the, if you wrote, go by AM,
Have an exercise all jurisdiction.
so and so, and thereafter explanation, the suit and proceeding referred to in the subsections are suits and proceeding of the following nature, namely, if your lordship kindly comes to F now. So a suit or proceeding for maintenance. Now, if your lordship goes again to 7.2,
Yes,
subject to the other provisions of this act, the family court shall also have an exercise, the judicial accessible and so and so under chapter 9 related to this so and so. So chapter 9 relates to 125 proceeding, that is maintenance. Now, lordship, another thing, if your lordship kindly comes to the provisions for appeal,
no, just.
there is a family court act can exercise powers under 125 of the CRPC. That is what it reflects.
Correct.
Now, lordship will kindly come to paragraph, section 19 relates to appeals.
Yes,
Chapter 5. Now, lordship, 2, Milord. 19.2. No appeal shall lie from a decree or order passed by the family court with the consent of the parties. Now, Milord. Or from an order under chapter 9 of the Code of Criminal Procedure. So, Milord,
and chapter 9,
chapter 9 is
What?
125 proceeding. 125 CRPC.
no appeal shall lie from a decree or order passed by the family court with the person.
Consent decree in a civil suit, Milord, in a family
Or
matter,
from
Milord.
an order
Oh.
passed under.
Chapter 9 relates to 125 proceeding under the CRPC. So, lordship, now, if your lordship kindly comes below, 5.
Hmm.
5 Milord except no appeal or revision shall lie to the court from any judgment so and so. An appeal referred to under subsection 1 shall be heard by a bench consisting of 2 or more judges. Now, it's an appeal, Milord. Now, first thing it says that revision appeal does not lie. And if it is an appeal, it has to be heard by a division bench. So that is the confusion. Here is a case which was filed under the CRPC. It is a proceeding under 397/401 CRPC. It's a revision petition. The act says
Revision petition under which provision?
397 for biology. It's a 125 under the CRPC.
They have used 397.
Yes, yes,
See
yes.
what
Yes, yes,
the provision
Yes, yes, Milord. It's since it is the new act came formula, section 438 read with section 442.
under section 438, there is section
Of the-
442.
Yes, under the new acts, BNSS.
Let us see. Read with section 528.
Yes, Milord.
So 528 is inherent power.
Yes, Milord. For it.
Huh?
It's for it. Here it was earlier. It was Milord.
If there is a specific provision, why you using the inherent provision?
No, Milord. It's a red bit. That is basically red.
Why should it be read with?
There is no bar as such, Milord. But the fact remains the 438 and section 448, which was earlier 397 and 401 of the CRPC. That is there. The fact remains, Milord, it has to be nomenclatured as revision. If it is a revision, Milord, under the Family Courts Act, appeal is not maintainable. So these notifications, Milord, in fact, has created doubt. Leaving apart the fact, Milord, that Lordship, the family principal judge of a family court, as well as the district judge, they exercise the same power. Now, because of this notification, an order passed a division, divorce petition can be filed before a district judge as well. An order from a district judge has to be assailed before a single bench. An order passed by a family court has to be assailed before a division bench. Same powers exercised by concurrent jurisdiction. But only because of the fact that there is a provision that it shall be it shall be before a division bench. This notification was issued. But so far the revision part, Milord.
Yes, ma'am. An appeal shall have to be in office. So is the interim order under 125 an interlocutory order?
No, it's a final order. It's a final order. the final order.
No appeal shall lie from an order passed under chapter 9. Maintenance of the no appeal can be filed
Yes.
against the 125 order.
And you know, the Guwahati High Court rules also.
Thank you.
But it will be- the thing will lie before, isn't it?
Initial notification was on a single bench, thereafter it was referred to a division bench.
Where?
The notification of 21st of March 23, it was to be listed before an honorable single judge, civil bench.
For the honorable division bench.
Now, subsequent notification says it's a special division bench.
So your order has been issued by whom? The
By the
order
fam-
under challenge,
By the family court.
by
Principal.
the family.
Yes.
So family court will come here.
No, but the act says, the family court act says it's different, my lord. No appeal shall lie. So it cannot be taken up. And in fact, my lord,
So
The
this is not-
notification-
So this is not an appeal, this is a
it's a
revision.
revision period.
Then
So revision, my lord, there is
this is not an appeal, this is a revision.
no, my lord. If your lordship kindly goes to by 1906
1960.
again,
Ah.
an appeal shall be heard. This is not an appeal.
Correct,
An appeal shall be heard by a division bench consisting of 2 or more judges.
but there's no bar for two or more judges
So
to
that
hear
is what-
revision.
If there is no bar, my lord,
No, where,
You are covered by this.
where is the bar for the division bench to
but
hear?
that is, my lord, beyond the act, my lord. That is what I'm pointing out to the law.
No, there's no bar. It doesn't say that the revision petition has
Okay,
to be
lordship
heard
takes
by.
up, my lord. If lordship takes up, I have nothing to
No,
say.
no,
Just- I
you
just
tell us
said-
where it is. Yeah, you're making a mountain out of a molehill, there's nothing here.
No, because, my lord, because the act itself says, there's a notification.
Only,
Can a notification otherwise, my lord, can a notification override the act, my lord? That is,
no, but where is it overriding? Where is the inconsistency? Sure.
the 1906,
So,
my lord,
you see,
1906.
you cannot put an appeal and a revision in the same state jacket. It's different.
Different, my lord. That is why.
An appeal is to be heard by division bench. There is nothing which says that a revision petition cannot be heard by a division bench. Where does it say that?
If your lordship, I have no issue. I pointed out.
Not
My
us. The-
lord, that is why I pointed out. my lord.
You are trying to.
That is to our understanding, my lord, that a revision
There's no bar.
of the forum. In fact, the only thing, my lord, here in this case,
We have wasted enough time on it.
no, if your lordship, that was what was confusing us, my lord. In fact, on the last occasion also, my lord, in a different case, this was discussed, my lord, whatever. The only thing, there are 3 or 4 cases pending between the petitioner and the husband. Here is a case where, my lord, there's an interim order if your lordship sees
You have been directed to pay 13,000
13,000
to the respondent wife
lordship.
and 4,000 to the.
Yes, sir.
Any objection?
No,
Why?
your lordship, because some accommodation.
Well, on the prayer for adjournment made by Mr. A.
Your
Raman.
Honor.
That counsel for the apparent husband. Which is not objected to by Ms.
MP Brown,
M.K.
Brown, PROW.
Brown.
Yeah.
You're what?
Yeah.
You're from Meghalaya? No.
From Guwahati.
Ms. M.K. Brown. Legally counsel for respondent number 1. List the matter.
Well, can you keep up next week?
Basically, your divorce decree has been, divorce has been rejected. So this, page 31,
Lordship.
is rejection on 15/10/25. Then
14/11/25, Your Lordship. Then
15.
no,
Not
Lord.
14.
No, Lordship, 14/11.
15/10.
15/10 is the order case 30, Your Lordship. This is not the impingement, Your Lordship. Case 31 is the impingement.
Okay.
After rejection, Your Lordship, for the second time also, another bill application was filed.
Where? Page
Case 35. On the same rejection ground that was rejected, Your Lordship.
So what is your ground? Any other bail
Lordship, is so far the consideration of bail by the learned special person is concerned, it is the embargo has to be 43D of the UAP has to be considered in while considering the bail application. 43D?
Why?
43D, because this offense alleged to have been committed is the UAP Act, section 17, 18, 39 and 40 of the UAP Act.
What? And UAP Act.
Lordship. The court has to primarily satisfy the reasonable ground, believing that the accusation of the involvement of the accused is primarily true. If in absence of that, your lordship, otherwise the court has to grant bail to the accused. But so far the ground projected, it is nothing has been mentioned in this imperial order. OT3D is the embargo lordship that has been regarding consideration of the. 43D, subsection 5, your lordship. The subsection 5 is related to the consideration of the bail. There must be satisfaction that the primary case against the accused person.
Section?
43D.
No, we are not on that.
5, your lordship. 43D, subsection 5, your lordship. May your lordship.
Yeah.
Notice contained in the court, no person accused of an offense punishable under chapter 4 and 6 of this act shall, if in custody,
I don't know why you are arguing in that line. We've got, we fail to understand why you are arguing in that.
lordship, but the ground, the into rejection, your lordship, does not in conformity with the provision of that, your lordship. So far the rejection order on the basis of the objection raised by the IO and for non arresting the other accused, your lordship, kindly have a look the ground, your lordship, that has been projected in this information.
No, it is, you are arguing this all wrong. Your argument should be, where is the connection between smuggling and this terrorist activity?
Lordship.
This is a case
Lordship.
smuggling of Erica nut, betel nut.
They could not produce a document.
So that is the, now where is the question of UAPA Act coming into play? Where is your allegation that these smuggling things are for terrorist activities? They're going to shoot themselves and going to blow up or something? I don't know. Huh? People not, what's going to happen if you chew it, what will happen? It will blow up in your mouth or something or what? Or is it for some terrorist act? Where is the connection between the UAPA Act?
Lot
And
let
the
the
Erica-
city be there then, lot,
Huh?
because the earlier the bail were rejected on the ground that there was sufficient incriminating material.
No,
Lordship,
it says that it was rejected on the ground that uh,
Considering the materials available in the case diary
yeah,
and view of the objection raised materials, there are materials, so let us see the case diary. Lord.
material, but material not in relation to terrorist activity.
So that will be clear. Let us bring the CD back because twice it was written, twice.
You see, it says here, come to page 32. It is the version of the IO that a tax invoice alone cannot serve as a valid permit for interstate transportation of Arikana. Peruse the case diary. So, it is highly suspected that the state tax invoice is false. But where's the connection? Supposing they were transporting rasgullas from Burma, then how do you make the connection? I agree that these Aricanas could be smuggled Aricanas because there's been a lot of smuggling of Aricanas from lot from state to the state of Mizoram also. But then where is the connection? No whisper of a connection.
Lordship super sanction, that is also not in presence in this.
And you give you chance, one chance to people come for the first time. But there's nothing.
Only let the CD be there after going to Lordship. Lordship,
There's nothing mentioned.
UAP regarding UAP there is Lordship.
There has to be some connection. You cannot just put in some stringent law without there being any connection. And what is the time period for filing a charge sheet?
90 days. Sir.
90 days. So that is over.
Lordship, that's
Then-
not late. 90 days of
They are beginning the
Where is 90? Where does it say 90 days?
FIR,
Lordship, it is
Okay, we'll list it on Monday
Lordship,
or Friday.
Monday, Lord.
Monday.
Because Friday, that matter may be a.
Correct. That is all. I think the thing is that we pick up to you. How to close the European?
yes, 43D subsection 2 speaks about the period. Lordship.
Right. Madam, yes,
Yes, madam.
they are accused of smuggling betel nut,
My lord,
betel nut.
lordship.
How does UAPA Act come into play?
At the face of it, my lord.
Yes, anyway, right. Heard Mr. Elmore, that it's asking for the certificate to submit that the petitioners have been arrested and are in jail on the ground of illegal interstate transportation of Harikana on the basis of fabricated tax invoice. He submits that the petitioners, the appellants or what is this? Appellants. Appellants were arrested on
Well, it was arrested on 10/10, your Lordship, they,
10.
11/10. Lordship.
11/10/2025. And though charge sheet is to be filed within 90 days, the same has not been filed. On perusing
Indo-Myanmar border and Mongolia.
Petition, we find that the petitioners, the appellants have been charged under various sections, including under the UAP Act, UAP Act, 1967. We fail to understand as to how the UAP Act is effective to the facts of the case. Our keeping in view the orders dated 14/11/2025 and
Lordship, I have got
P1
why UAP is added note. In the forwarding that is there, the accused person has admitted that a significant portion of the profit generated from the smuggling operation is being shared with these terrorist outfits. In the forwarding. For that UAP is there.
This is forwarding support FI is
No, no,
Silent.
what I have seen, why UAP is there. Because
forwarding is
forwarding of
subsequent to the allocation of
these
this.
funds are being utilized by such organization to finance
Huh?
anti-Indian activities.
Yeah. P1/2026
Page number 24. Okay.
passed by the special judge at Karachi while rejecting bail application number 96 of 2025 and 108 of 2025. Yes, sir. Ms. Abegam, additional 50 submits that she will produce the record.
Yeah.
She will produce the
Yes, sir.
CD.
Yes, sir.
CD. On the next day. And he will also obtain instructions as to the time period within which charge sheet is to be filed.
Yeah.
Different. So you take that because 90 days is over.
Well, Lordship, yeah, sometime it only
List the matter on
Monday.
Monday. Okay. You see, Miss, Madam. You see, if they say that this is going to be given shared with the terrorist organization, that the name of the terrorist organization is mentioned or not?
That will be, I'll go to the CD, Lordship, then only I'll be here.
Not only that, there has to be a declaration made by the central government.
Look.
To the terrorist organization. Nothing to- Huh?
Then out.
Yes.
May I please your lordships? Lordship, Mr. Sejal is not available today, lordship, due to some medical urgency. Lordship, the matter will be taken up next week. Moreover, lordship, the petitioners have filed a petition affidavit, your lordship, highlighting the substantial question of law. So we need some time to reflect upon the same.
You're for whom?
The lordship, a central excise department.
Yes, so has the, duty been passed on to the consumers or not?
Not,
Huh?
no loss.
No.
Because
How-
it was the goods which has been accessible as per the responding loss authority. It was not separately sold. It was just captively used to the ship as a adhesive to regarding the production of that.
Please understand the question put to you. Whether the duty has been passed on to the consumer.
It was not possible.
How do you say that?
Because as per instruction from a client, was it was stated that it was not.
Your inspection, is it in writing?
No loss. But
You take it down in writing.
loss in yes. Loss in the take out.
That is the only issue.
Yes.
Once, if it has been passed on, then there cannot be unjust enrichment because for the simple reason,
But I have
That-
made out three substantial questions of law. Loss.
maybe you
Yeah.
can have 20, 30 also. But the fact remains that the core issue is this. All right, on the prayer for adjournment on business on behalf of the state, this is the matter after the week.
Of that.
Your paper book is ready, madam.
I know WO is ready also.
Yes.
So, yeah, we can dispose of the IO, the IA.
Like to copy the book.
Yes,
Yeah.
okay, right. As per the office note dated 27/11/25. Notice has been received by the respondent. Or in notice deemed need to be copied. However, no one appears for the respondent. List the matter. No, as the written objection has been filed by the state, list the matter. When? After 2 weeks.
They can says there are paper book.
This is the matter after 3 weeks. The
paper
matter after 3 weeks. So then in the main appeal, you right? Here in this appeal on, as as PCR has arrived, registry to prepare the paper. This is the matter you did.
20.
Make it 4 weeks, doesn't matter, 4 weeks.
So they make no appeal, earlier trustee service.
Yeah, we have undertaken justice service.
My lord, nothing. An affidavit has been filed.
And what about speed post? Did you take steps?
That is
But we need some, the other side now. Lordship, some time be granted for this.
Okay, right. As PCR has arrived, the registry to prepare the paper. This is an appeal against the convict, no, forget that, already there. That's right, Miss, P. Priya, learned APP. 6 times. For training instructions afterward. Notice has been served upon the respondent. List the matter. After 4 weeks. Then in the IE, right? Miss B. Brian, additional PP is granted. 4 weeks time to file it in a bit. So the application under section 430. Really. This is the matter.
Get a date for lordship.
Give a date.
Publish.
What has happened to notice out here?
Yeah, also, should we need to take this option?
Okay, right. In the criminal appeal, you right? As PCR has arrived, registry to prepare the paper. The APP may be Brian can obtain instructions with regard to service of notice upon the respondent. Then in the IA, you're right. Ms. P. Brian is granted 4 weeks time to file written objection to the application under section 430. In the criminal appeal, you authorized as PCR has arrived, registry to prepare the paper. Okay. Oh, already there. This is the matter of the court.
63. Then to the 60. Well, copy that.
No objection, madam?
Yes, yes, we need to find it.
No objection.
Oh, here, no.
Mr.
Yeah, Chair.
A. Atreya, learned counsel for the applicant. Praised for condonation of delay of 88 days in filing the appeal against the conviction of the appellant under section 302/341 IP.
Only 302 Lordship. There is
302 IP. Ms. P. Brian, additional 50 subject that says of no objection to the delay being. India, the sufficiently by the past for the party, the delay of 58 days for no. Registered to with the AP. Higher accordingly, it was. Yeah, Miss S. Mehdi,
Yes.
now there's 403 days delay, yeah,
May I please your lordship?
for the others, everything's taken.
Oblige. Oblige.
Okay, Miss Mehdi and, yeah, wait, we can do it now also, no, instead of this thing. Yeah, I mean,
Oh, yesterday's.
that yesterday's matter, there is no need of,
Please, sure.
that there is no requirement of, VC proceeding. For the simple reason that the charge was framed under section 8.
Eight, okay.
And now we are only converting it to 10.
10.
8 and 10, the only difference is because of 9M, wherein child is below 23, 123.
23 or 26, Hailakandi. This is the death certificate. My lord will file the death certificate at page 86. Hailakandi. Thank you.
Lordship, may I take instruction from the jail authorities so that they can go and verify whether his mother has been expired?
So, my lord,
Lordship, when the
okay.
2 o'clock.
PP expired, also?
23 one.
23 one.
23 one.
We take it up at 2 o'clock.
I need a question.
Mother expired, you can't wait. There are so many things to do. Today is 28, in fact.
Yes, ma'am.
Lordship, if I'm not here, then I'll inform my landlord.
Okay. Just take, we'll take it up at 2. At 2. Try to get the information. We have to do something.
Yes, ma'am.
Yes, 11661, my lord. There was an order, my lord.
Yes.
May I reappraise the facts of the case, my lord, for my lord better understanding? So, my lord, the facts of the case is that around 13 to 2022,
We are on the IA or on the?
on the criminal appeal, my lord, hearing. Item number 15.
One seven.
219. 219 and 179. Both.
This is the IA. Maybe no, this is the.
Same paper.
Paper book is the same, my lord.
Why is it 2 paper book?
My lord, because there are two different cases. 14, 15, 14 and 15 are linked.
But same witness.
Same. Everything is same. Judgment is also same.
One paper
One paper book.
2 different cases.
Yes, my lord.
filed by two advocates.
Filed by two different.
Two
applicants.
accused of the same case, but
Okay.
filed by two different.
Okay. Yes.
So, my lord, on 13 to 2022 at about 10 a.m., the PW4, who is one Shri Sanjeev Goswami, who is a certain teaser officer, is an ASI of the Assam Police, had received information from reliable sources that certain ganja peddlers are bringing in a lot of ganja in coach number B1 of Deoghar Weekly Express, which was coming from Agartala railway station towards New Bongaigaon. The same was reduced in writing, and thereafter authorization was issued to the PW4 by one Shri Sanjay Kumar Lashkar to conduct a search and seizure of the said contraband, while authorization letter dated 13 to 22. Thereafter, my lord, when the train arrived at New Bongaigaon Junction at around 1338 hours, the PW4, who is the search officer, boarded the train along with 6 other policemen. And my lord, inside the train, they apprehended the accused persons. Search proceedings were concluded. The accused persons were deported from the train.
You mean the PW4 is the informant.
Is the informant, is the search officer also. Is an ASI.
Also,
So thereafter, my lord, what happened is that the accused persons were deboarded from the train along with their luggages. And at 2:15 a.m., my lord, an FIR was registered. Teaser list was not done by that point of time. Only an FIR was registered, surprisingly indicating the quantity of the contraband. And thereafter, my lord, Caesar was finally effected at 1600 hours by PW6, who is the OC, and also the IO. So, my lord, may I take your lordship through the witnesses, the independent, the so-called witnesses. Before that, my lord, I'll be arguing.
no, 52A was followed.
52A was not followed in to certain extent, my lord. You know,
Followed on that.
my lord, I'll be arguing broadly on three grounds. The first is the prosecutions. My lord, I've given a paper book on the other, on the previous occasion. I'm sorry, my lord, I've given a compilation of judgments. Okay, I think that's okay. Huh? That's okay. Okay.
Uh, correct. Keep on sharing one.
On the previous occasion, my lord, in fact, on the last occasion, it was there on the file. I had verified it.
The problem is what happened is probably the data
Misplaced.
it out. It could be that paper, no, but why should be missing for both? If it was missing from one, then
Why
I
not?
can take it. But missing from both are files. Not possible to be kept.
So, my lord, I'll just argue on I will not go to the entire judgment. I'll just read out the relevant paragraph for my lord better understanding.
These are the relevant.
The relevant paragraph.
And then we will have to change the paragraph. I know you tell us what are the key parameters under which?
Yes, my lord. Yes, my lord. I'll do that.
What?
So, my lord, the first ground that I'll be arguing is the failure of the prosecution to establish the conscious possession. The failure of the prosecution to establish the conscious possession of the contraband from the appellant.
Then? You have given so many heads. You said
My lord, three grounds I'll be arguing on.
one is
The
failure.
failure of the prosecution to
A,
establish
then number
B, failure of the prosecution to prove the secure chain of custody of the alleged contraband from the recovery of the contraband from the recovery of the train till the production of the same before the laboratory, before the FSM.
then
So I've combined B and C together.
uh,
And my lord, the third ground that we'll be arguing is non-compliance of section 41.
and B and C, you mean non-compliance of 52A.
That, my lord, I will argue with the second ground. The failure of the prosecution to prove the secure chain of custody of the contraband from the recovery.
That's what I said. No, what is that lowest justice? That is it. It is there. It is. It is it. It's it. Ah,
My lord, may I first take your lordship to the evidence of PW 1, 2, and 3, who are the independent witnesses. My lord will find in the paper book. Page number 7, my lord.
Yes.
The fourth line, my lord.
One, page number 7.
Page number 7, my lord, the cross. May I read it? Yeah. I cannot say from where the GRP personnel recovered the trolley bag and sack containing suspected ganja. The distance between my stall and GRP office is about 150 meters. I did not go to GRP office. I was at my stall. In the railway station, railway employees, TT passengers, etc. remains present. In New Bongaigaon railway station, train comes and goes within half an hour, within about half an hour. I cannot say if the license of a vendor expires, he is arrested or not. I watched, my lord, this part is important. I watched the measurement of a ganja from a little distance. I do not remember my signatures were taken by GRP. And this is the most important part. I cannot say who were present at the time of measurement of ganja and who boarded the train for conducting such. Now, my lord, the second PW, the second independent witness.
How would you expect a person to know everyone? He's
My
an
lord,
independent.
my
witness.
lord, my submission is that they were not inside the train because the seizure was conducted at 4 o'clock in the platform. So, and before that, my
One
lord,
knows. So if you've got around 5-6 police personnel along,
none of them were examined, my lord. That is my second ground. 114G of the Evidence Act is being hit. So, my lord, may I take your lordship to the PW2, the second independent witness. Page number 9.
Yeah.
My lord, the fourth paragraph. My tea stall is in the middle of the platform. I did not enter the coach. I was in my tea stall. As soon as train arrived, crowd gathers in my tea stall. At this time of selling things, I become busy for delivering goods and taking money. I cannot say how and from where inside the train GRP recovered the trolley bags and plastic sacks. I saw the same only after they got down from the train. I do not know the names of the GRP personnel. There were about 2-3 GRP personnel. I do not know the names of the GRP personnel who measured these articles and prepared the season list. I do not know from which accused how much suspected ganja was recovered. Thereafter, lordship, may I take your lordship through the PW3. This is the third independent witness. In page number 12, the second line. I was busy in my tea stall. I do not know from where and from whom GRP personnel recovered the suspected ganja. I have seen that the GRP personnel were measuring the suspected ganja. I have put my signature as told by GRP personnel. I do not know who prepared the season list. I do not know what was there inside the bags, inside the seized bags. I do not know how many GRP personnel were present at the time of measuring the seized articles. So, my lord, these witnesses were supposed to be the independent witnesses, but they only witnessed the seizure proceeding, not the search proceeding. So, my lord, if I go through the chain of the facts of how the things uncovered, the search proceeding happened at 1338 hours inside the train. Thereafter, along with 6 other police personnel, they were deboarded, brought to the platform. FIR was registered at 2:15 p.m., surprisingly indicating the weight of the contraband. I'll take your lordship to the FIR also. At page number 4. With reference to the subject cited above, I have the honor to state that on 13/2/2022 at 10 a.m., an information was received by me from reliable source that some cannabis ganja peddler are bringing in a lot of cannabis in coach B01 of Deoghar Weekly Express train, bearing train number 15626, which was coming from Agartala railway station towards New Bongaigaon Junction. In this regard, I informed Sanjay Kumar Lashkar, IRP Fakiragram, Camp Bongaigaon. Accordingly, a written authorization was issued to me by IRP Fakiragram, White so and so, dated 13/2/2022, which is empowered by Government of Assam with notification number 212 under 41(2) of NDPS to carry out search and raid. When the train so and so arrived at Bongaigaon, junction at around 1338 hours, the police party headed by me, along with police personnel namely HC Puneshwar Roy, Dharani Talukdar, Sapan Kumar Rai, Nitul Deka, Pinkumoni Ray, Bijoy Das. Now, my lord, I pause here for a bit. None of them were examined and adduced as prosecution witnesses. During the search, the three suspected passengers, one with blue color trolley bag and the other with two plastic sacks, were noticed avoiding police team and trying to escape from the search coach. But in the meantime, they were intercepted and their belongings were searched thoroughly. During search, one blue color trolley bag containing one number of packet wrapped with brown color tape suspected to be ganja was found from the possession of the Suraj Kumar Ray, which is the present appellant, son of so and so. One purple color plastic sack containing suspected to be ganja was found from the possession of Shri Bipin Kumar, Richard Bay, son of so and so, and Veera Mahato, son and so and so. When the train, Deoghar Weekly Express train bearing train number so and so was about to depart from New Bongaigaon junction towards its destination, the police team apprehended all the three persons along with recovered ganja and deported from the train and returned to the office of the NBQ GRP IC at 1340 hours. The total weight of the recovered ganja is approx 21 kgs. So the FIR is registered at 2:15 p.m. My lord will find at page number 1. Thereafter, lordship, may I take your lordship to the Caesar list? There are two Caesar lists. The first is at page 72. Page 72, man. This is the first is the Caesar list which was done at about 4 p.m. And this is from me, Suraj Kumar Das, Suraj Kumar Ray, and the total weight that has been recovered from me is 10.210 grams of 10.210 kgs of ganja. Interestingly, my lord, there is no indication as to whether the contraband was sealed at that point of time. I'll come on later, my lord, because that also has a significance. Thereafter, my lord, the second Caesar list will find at page 73. That is the contraband which was recovered from them. That is also about 10.80 kgs of ganja at about 4:30 p.m. Now, my lord, may I take your lordship through the evidence of PW4, who was the search officer. Page 13. Informant. Page 13. I read from the fourth line, my lord. After receiving the information, I entered the information by GD entry number 171 dated 13/2/2022. Exhibit P3 PW4 is the extract copy of GD entry number 171 dated 13/2/2022. Exhibit P31 is my signature. I informed about the matter to OC Bongaigaon GRPS and IRP Fakiragram camp at Bongaigaon. I was authorized to conduct search. Exhibit P4 is the authorization letter which was sent to me through messenger. Exhibit P41 is the signature of Sanjay Kumar Laskar IRP Fakiragram, which I know. Deoghar Weekly Express arrived at New Bongaigaon station at 1338 hours. I, along with my staff, boarded the train and conducted search in coach B1. While search, I found 3 persons. 2 among them were holding purple color plastic sack and 1 person was holding a blue color trolley bag, and they were trying to go to another coach avoiding search. We restrained the 3 persons and searched them. On being asked, they told their names to be Suraj Kumar Ray, who was holding the blue color plastic trolley bag, and the other 2 persons holding the purple color sack to be Bipin Kumar and Veera Mahato. On search, we found suspected ganja in the purple color plastic sack and blue color trolley bag, and accordingly, the 3 persons were taken out from the train. I informed the matter to OC Bongaigaon GRPS. He said he will come and seize the articles. Now, my lord, I asked myself a question. What stopped him from conducting the seizure at the point itself? After deboarding them from the train, Why did he have to inform those? He was already authorized officer. He had the power to search and do the seizure. Why did he not do that? Thereafter, my lord, we took the 3% along with the recovered articles to the platform number 1 in front of GRPS office of officer OC Bongangao GRPS Madan Chandra Kalita reached there, seized and measured the articles in presence of my witnesses. I was also present there at that time. So if my lord, if the measurement is done at 1600 hours, how come the measurement is there in the FIR Act, which is registered at 215? Who did the measurement, my lord? Thereafter, my lord, the cross at page 17. At page 16, my lord, the third paragraph. I did not make any GD entry after being authorized for search. Thereafter, my lords, on page 17, the third paragraph. When a train reached station, passengers board and get off the train. I did not seize any train ticket from the accused persons. The accused persons belongs to different states. They are not relatives. My lord, the IO is himself saying that they are not at all related. And section 29 has been added, but no evidence has been adduced to support the claim of section 29, nor has been discussed in the judgment also. Thereafter, my lord, railway tickets are available online. One copy of train ticket in the name of Suraj Ray is seen in coach number B1, seat number 19, upper berth. Another copy of train ticket seems to be in the name of Bipin Kumar, Veera Mahato, coach number S2, seat number 8 and 6. This is corroborated in my 313 statements also. That we were in different compartments. Then why the ticket was also not seized, my lord? Thereafter, my lord, seizure list was prepared by Madan Chandra Kalita at 4:30 p.m. after measurement. I did not do any measurement. He's again himself saying that I did not do any measurement. The weight of the suspected drugs mentioned in the HR and the actual measurements are the same. I did not inform my higher authority. This is, my lord, violation of section 57. Thereafter, my lords, may I take your lordship through the in chief of PW6, the IO, and the seizure officer. Page number 22. The third line from bottom, my lord. I visited the place of occurrence at New Bongaigaon railway station, platform number 1, in Deoghar weekly express train number 15626, coach number B01, along with ICGRPS. I recorded the statement of the accused persons. Thereafter, lordship, I'll take you to the cross at page 24. The third line. I reached New Bongaigaon GRPS at about 3 p.m. The description of trolley bag is not given in the seizure list. The weight of the bag is also not mentioned in the seizure list. Although I have mentioned the weight of ganja, I did not collect the list of position of coach number from the station master. My lord, this part is important because this is one aspect which I'll be relying in the cases that I'll place my reliance on. I did not seize railway ticket from the accused persons. It is not a fact that I did not visit the place of occurrence. I have not made any prayer to record the confession statement of the accused person. It is not the fact that accused persons did not pay before me that due to shortage of money, they decided to do ganja smuggling, and accordingly, they have purchased 21 kg of ganja for 31,500 from 2 unknown persons. I have not recorded statement of any witness who were present during preparing samples. There is no signature of accused or witnesses on the envelope of samples. This is my lord violation of 52 and also the guidelines laid down by Mohanlal, by the Supreme Court in Mohanlal case. It is not a fact that the samples were not collected as per law. Now, my lord, this part is very important. I did not physically seize the suspected cannabis from the possession of the accused person. But my lord, who did it? Who did the measurement? The dots are not being connected. Now, my lord, so far as the examination of the other 6 police persons are concerned, may I take your lordship to section 114G of the Evidence Act? The court may presume the existence of any fact which it thinks likely to have happened regard being had to common course of natural events, human conduct, and public and private business in the relation to the fact and particular cases. Illustration: the court may presume subclause D that evidence which could be and is not produced would, if produced, be unfavorable to the person who withholds it. So, my lord, had they been put into the dock during a cross-examination, there might have been certain things which would have come out and which could have gone against the prosecution. Perhaps that is why, my lord, they were not adduced as witnesses. So now, my lord, I'll come to the case law.
We will take it up at.
Jail information, jail officers do not have the information. I tried to collect information from the OC concerned. So as of me, but there are provisions in the jail manual, your lordship. We may apply to the superintendent district jail, emergency circumstances. The prison leave and emergency release rules, 96 is there.
There is, my lord. But then the problem being that, my lord, there is a provision of section, the definition of sentencing. The Assam Prison Leave and Emergency Release Rules 1968. There,
What may happen?
subclause F, my lords will say,
Correct. Lordship.
subclause F says sentence means a sentence of imprisonment. F of definition clause. Sentence means a sentence of imprisonment as finally fixed on appeal or revision or otherwise and include the aggregate of more sentence than one but not include the sentence in default of fine. So, my lords, here is a case where the criminal appeal is still pending. It has not been confirmed yet. And in fact, my lord, there is a case also to that effect.
Anyway, you pay inspector.
No, see,
Ah,
jail do not
2
have,
o'clock.
superintendent do not have.
2 o'clock. Oh. Ah. I just mobile is, you can always find. Mobile is there, you can do it.
I don't know how
You
far
give
is
the mobile
village.
number.
I will do that. my lord.
You give the mobile
I will do
number.
that.
Ah. Mr. Ahmed, it is reading 2163. 2163 says that is no prejudice.
So and so. Conditions of emergency release, so and so, certain conditions can be says, shall not reside, children residence.
So we will just suspend we have to suspend the sentence.
For 15 days, my lord.
We'll suspend the sentence for 15 days.
He will be granted bail for,
We suspend the sentence for 15 days and the bail is given only for the 15 days. He will surrender.
Very well.
Then after 1 month, he'll say that I have not run away.
lordship may indicate the condition.
Ah. That's right. Heard Mr. S. Mitra, the learned counsel for the applicant. Also heard me people learned. AP.
Lordship, I'm so sorry to interfere. Can it be taken tomorrow then? Because I have talked to the OC,
Ah.
he'll obtain the required information. And after obtaining it, then he will be released, madam. Maybe taken up the first second.
My lord, what will happen is that after my lord give the order, the person has to come to Guwahati, take the order, again go back there. So traveling time is
Before
also there.
information,
No. My client has to take the
you
order.
have come on the last hour, no, why?
I know because the holiday is going on. holidays were there.
Can it
Fine,
be
yes.
taken up, lordship,
No,
because.
we'll
why-
give
just-
it,
just-
we'll
just,
give it,
Have
just,
it, lordship, on the 302, minor, it's a.
Sure.
15 days.
so what? So what? You haven't seen the news.
Lordship
Those
tomorrow at 10:30.
those powerful persons who have been given payroll 15 times already. And this is
Tomorrow-
mother.
I understand, my lord.
Sometimes you've got to allow them to go, right?
Then my submission is recorded.
This is the case. Really. I have this picture and, huh? This is an application under section 430 BNSS 2020. For suspension of the sentence inflicted upon the applicant by judgment dated court, no, by the sentence order dated 16/11/2020. Passed pursuant to the judgment dated 14/11/2024. By the court of the additional session judge, Hailakandi. In section case number 79 of 2015. By which the applicant has been convicted under section 148, 324/149, 325/149, and 302/149 by the impugned judgment and sentence order, the applicant has been applicant has been sentenced to undergo page 67. Page 67, this is to undergo paragraph 57. Next part, the applicant counsel submit that the applicant's mother has passed away due to a heart attack. And in a heart attack on 23/1/2026 at 6:30 AM. And in this regard, he has annexed the medical certificate, the death certificate of his mother, Srimati Rani Na.
Smriti Rani.
Huh?
Smriti Rani.
Okay. Srimati Smriti Rani.
Smriti Rani.
SMRITI Rani. Issued by the issued by Dr. Amalendu Das. PGT.
His designation be recorded, my lord.
Who is the SDM and HO, Lala EPHC. Lala P. The learned counsel for the applicant submit that in view of the above, the applicant, who is a Hindu Bengali, has to perform certain rites and rituals which are as follows. Page 11. Accordingly, phrase that the applicant may be allowed to go on interim pay for a period of 15 days. After which the applicant will surrender himself back to the jail apartment. Next, the learned EPP submits that the OC
Lordship concern, jail authorities do not have the information.
submit that the concerned jail authorities do not have any information regarding the death of the.
However, the
But
applicant,
the
has come to
applicant-
know- the applicant is aware of that.
However, as the applicant has brought the said issue before the court for the first time, the OC of the
Lala police station.
Lala police station has been informed of the state and asked to verify that the correctness of the submission made by the appellant. The learned APP submits that the matter may be listed tomorrow so as to enable the OC to ascertain and verify the fact. Consider the, no, though we are of the view that, though we are initially of the view that some time should be given to the OC of the Lala police station. Still, the practice of the we are of the view that as the this is, but this is a 1-2 only.
My lord, 1-2.
1-2, so today is 28.
28, my lord, the person has to come from Hailakandi here, he has to collect the order, go back there, do the formalities. This is a ritual.
This is the only time. So, whatever I said. Lala, the OC of the Lala police station to verify the city. Come on. We are of the view that some urgency is there, as the applicant is the only son. And the only son
Only child.
of his mother. And he has to perform certain rituals and responsibility. According to keeping in view the death certificate which has been issued on 23/1/26 by Dr. Amalendu Das, SDM in Echo, Lala PPH. We are of the view that interim pay should be granted to the applicant for a period of 15 days. Accordingly, the applicant is allowed to go on bail on furnishing a bond of rupees 50,000 with one surety of like amount to the satisfaction of the alleged plan. The interim bail will be for a period of 15 days with effect from the date it stepped out of the jail. Huh? And the appellant will, applicant will thereafter surrender himself before the jail authorities on the 15th day of his release. Consequently, the sentence order dated the issuing judgment is hereby suspended for a period of 15 days.
Worship with the condition, can you please cooperate with the order?
What condition?
Condition that he should not be out of the jurisdiction and other conditions, because he might like
He has to return back.
he comes with
If
your
he doesn't come back within 15 days, then he will finish. Upon the even if he,
by the process
that is
of
just for
order.
namesake, madam. Even if he goes to Timbuktu, we won't know. Nothing like that. And he's only a convicted felon.
The respondent worship, and for the respondent number 2, my name.
Miss A. Begum appears for the respondent. When is it? The application accordingly.
Highly obliged.
Lordship, if he absconds, my lord,
If he absconds, then, well, what to do? What to do? What? If he absconds, even if we put 1,000 conditions, if he absconds, he absconds. What to do? That risk has to be taken. Otherwise, we can put two surety. Two sureties of like. Satisfied, madam? Two sureties. No, even if we put 30 sureties,
Lordship.
if he absconds, he absconds. What-
My lord,
But the only thing is that when we grant bail, we cannot put conditions that amounts to denying him bail. No, the conditions cannot be such that will eventually amount to not being able to go on bail.
My lord, 50,000 each surety has to pay.
Too much.
Yes, my lord. He's after all a villager. I mean, I come
Okay.
from a very humble background.
Okay. Okay, we can have one surety. One surety.
Lordship, please
Huh?
fix the date.
Main case.
In case paper book is not yet taken.
Main case, you can list the matter after 4 weeks.
Lordship, please to fix the date in this matter.
Now give it.
I agree.
IA is my lord.
List the matter after 4 weeks as paper book has not been prepared. Hmm?
11 months. IA.
There is also interim, suspension is also only for 15 days.
Yes.
Interim bail is also only for 15.
I will still remain.
No,
IA is
it
dismissed.
goes up. Ah.
Bless me, lord.
Deputy to who? We won't wait.
So my lord, continuing with my submission.
Then you have the type of. Okay.
So my lord, continuing with my submissions. Before I come to the law points, my lords may kindly have the CRPC, the NDPS Act for a while. CRPC.
What?
Nothing, look.
So Mr. Mitra got married, I just remember.
Let please.
Recently, you know?
Yes.
They got married in Garo Hill. So where's the wife?
My lord in Shillong.
Shillong.
He has joined the duty now.
Working as what?
He's working as a undersecretary to the government of Meghalaya.
Oh, she's a government servant.
Yes.
In the Meghalaya Civil Service.
Yes. No, Meghalaya legal service.
Legal service. Okay. How come?
My lord here only in my lord's court.
Oh, very intelligent.
How she Meghalaya? How
My
come?
lord, she was working for Studio Nilima.
Huh?
She was working for Studio Nilima.
Oh, she was student in Lima. When did she join?
In 2024.
Oh.
Within 1 day.
Huh? What?
Within 1 year. 25. He got married.
No, she joined in 2024.
Oh. Okay.
Anyways, but why the Garo? She's a Garo.
She's a Garo.
Oh,
Her parents are in Pura.
nicely.
My lord, very much.
So now you're the son-in-law of
Garavins.
Garo Hill.
My lords may kindly have section 51
Ah,
of the NDPS Act. provisions of CRPC to apply to warrant, arrest, searches and seizures. The provisions of the code of CRPC shall apply insofar as they are not inconsistent with the provisions of this act to all warrants issued and arrest, searches and seizures made under this act. Now, Lordship, may kindly have section 100, subclause 4 of the CRPC.
Section 100.
Of the CRPC. my lord.
That is on search.
On search, my lord. Independent witnesses. Section 100, subclause 4. May I read you, Lordship? Before making a search under this chapter, the officer or other person about to make it shall call upon 2 or more independent and respectable inhabitants of the locality in which the place to be searched is situated, or of any other locality if no such inhabitant of the said locality is available, or is willing to be a witness to the search to attend the witness, the search and may issue an order in writing to them or any of them to do so to do. Now, my lord, why I'm reading this out is because, my lord, all the independent witnesses, they were not arranged for. They were taken up directly from the platform after the search was made. No attempt was made to arrange for independent witnesses, despite the fact that they had prior intelligence. This is not a case of chance recovery.
So what happens if this is not followed? Is it mandatory?
And that's what, my lord, I'll come to the case laws. It will not vitiate the trial, but
It will not
it
vitiate.
will put a dent on the prosecution story, because that is one aspect of the matter, but there are so many other procedural flaws which I'll take your lordship through now.
So basically your entire case is that it might not be mandatory all your points, but each point is going to cause a dent in the.
Yes, my lord. So, my lord,
That's your basic case.
yes, my lord, for section 44.
For only 2 minutes.
Huh?
It was in the train.
Ah.
The train wait there only for 2 minutes. 38, the train have reached. They have went inside the train and brought him down. It was 40.
So, my
In
lord,
2 minutes.
my submission is
So
that-
there was no independent.
my submission, my lord, they got the information at 10 a.m. 10 a.m. they could easily arrange for independent witnesses.
No, but then sometimes the information is not correct. Sometimes if they get information,
My lord, there were 6 other police officers.
maybe
They were not examined. They could have been examined.
police officers and independent witnesses are different. No
My
one
lord,
likes,
my lord,
no one likes to be a witness.
my lord.
I'll tell you why. There's many problems. You see, in a lot of places, the witnesses' complaints are that we come from villages, we take sumo whole day, we come to the court from the morning to evening, the court doesn't treat us with respect, they don't even know that we are there, they make us sit outside, a whole day, they don't even give us tea, they don't give us anything, and we are poor villagers, and then sometimes without even giving us a chance to say anything, they give us a new date, and then we have to go with our own money back to our village. So there's many a problem.
I do appreciate, my lord. And that's a fact that.
So that is why, but you cannot be so strict on
No, my lord, I'm-
requiring
but
the
my-
presence of a witness.
My lord, my submission is that there were 6 other colleagues also. Why were they not examined?
Like they say,
Because-
evidence is not counted, it is weighed.
My lord, that is one way of looking into it. The other way of looking into it, if they were cross-examined, might be something would have come out which could not corroborate with the evidence led by PW4. The 114G of the evidence act, the best available witness.
Okay. That's it.
My lord. So, my lord, the first case I'll be relying is Thaunam Purnima Singh versus Union of India. The relevant para will be 16. This, in fact, will answer my lord's query. May I read it, Lordship? Yes. Section 51 of the NDPS Act provides that the provisions of the Code of CRPC 1974 shall, insofar as they are not inconsistent with the provisions of this Act, to all warrant issued and arrest, search and seizures made under this Act. Subsection 4 of 100 CRPC provides that before making a search under this chapter, the officer or other such person about to make it shall call upon 2 independent and respectable inhabitants of the locality in which the place to be searched is situated, or of the other locality if no such inhabitants of the said locality is available or is willing to be witness to the search, to attend and witness the search, and may issue an order in writing them or any of them to do so. Subsection 5 of 100 CRPC provides that search shall be made in their presence. Therefore, as per requirements of subsection 4 and 5 of 100, read with section 51 of the NDPS Act, the officer making search is under obligation to make an endeavor to call upon independent and respectable persons of the locality where search is conducted, or from any other locality, and the search shall be conducted in their presence. The contention of the learned counsel of the respondent on the basis of various judgment of the Supreme Court is Gyan Chand and others versus State of Haryana, Appalabhai versus State of Gujarat, and Baldev Singh versus State of Haryana, Ajmer Singh versus State of Haryana, and State of Himachal Pradesh versus Pradeep Kumar, is that presence of independent witness at the time of search and seizure is not an indispensable requirement, nor the absence of independent witness vitiates the trial. There is no dispute as to the above legal proposition that absence of independent witnesses at the time of search and seizure per se does not vitiate the trial. But the question remains is whether the officer conducting search and seizure made an effort to avail any independent and respectable witness to see the search and seizure. Because the amendment of the legislature requiring the presence of independent and respectable witnesses at the time of seizure is amply clear, inasmuch as such provisions are intended to provide transparency and credibility to the search and seizure. Mind this part is important. There is no difficulty in understanding that there may be circumstances when it may not be possible to have any independent and respectable witness at the time of search and seizure. But the crucial question is whether any endeavor is made to call upon any independent and respectable witnesses at the time of search. If the search and seizing officer does not make any endeavor to call upon the independent and respectable witness to witness the search and seizure, the proceeding may not be initiated for such lapses, but certainly the probability value or the credibility of search and seizure shall be affected if the statutory provisions are not complied with. So, my lord, here is a case, my lord, where it was a public place. It was a railway station. There ought to have been number of witnesses.
Haven't you seen in WhatsApp? There is a person lying dead on the side of the road. Cars are passing by, people are walking. He's bothered. No one likes to be a witness now.
My lord is correct, but my lord, independent witnesses were there. Those persons who were the tea vendors, they could have been taken during the search proceeding. They deposed as witnesses. They could have, might as well, they could have been collected and just witnessed the search proceeding. So the things would have been amply crystal clear. Now, my lord, the next is paragraph 21 of the same judgment. This court in SH Lalthama versus State of Mizoram also held that it is mandatory that the seized contraband should be produced before the magistrate first class, and then with the order of magistrate, the samples taken from the seized contraband to be sent to the forensic science laboratory for examination. The law in this regard is well settled by Honorable Apex Court in Mohanlal and others. It is a settled proposition that when the offence is serious, providing stringent punishment provision of law is required to be scrupulously followed. The failure of the investigating agency to comply with the statutory requirement as to search and seizure in the facts and circumstances of the case seriously affected the credibility of the prosecution case, and benefit of such effects would certainly go to the accused. In the present case, it is evident that the contraband was recovered in front of the GMCH, and the investigating agency took possession of the contraband. Neither the contraband was seized at the place of recovery, nor sample was taken at the place of recovery. Rather, the contraband along with the accused was taken to the office, where after taking sample, the contraband was seized. Admittedly, sample was taken at the customs office in total disregard to the provision of law and mandate of the Apex Court in Mohanlal's case. Evidently, presence of any independent respectable witness at the time of recovery was also doubtful. All these facts and circumstances, in my considered opinion, render the entire process of search, seizure, and taking sample highly doubtful. Next, my lords, is the judgment of Jagdish versus State of MP. This is an Honorable Supreme Court judgment. Paragraph 5 and 6. Page number 10. I read from paragraph 5. It has not at all been explained by the prosecution and by the PW1 as to why he brought down only one passenger from the bus. If he did not have any prior information or entertained any suspicion regarding the involvement of the appellant in possessing or smuggling of opinion, it is not the case of PW1 that he had any prior information and therefore he searched the bus looking for the suspect. In case he had some prior information, he was obliged to make a record of it and send its copy to higher officials before proceeding
Mr.
for,
Mitra, how long are you going to take?
my lord, as long as it takes to satisfy you, my lord.
No, because my brother has got a single bench. That's what he has.
My lord, few of the judgments, I'll just read the propositions of law.
How long?
Half an hour. Or my lords may keep it as a part of matter for Friday.
Was 50%. Friday we have 2 minutes. You know, we have 6 Tuesday. We fix on Tuesday.
My lord, but my lord, the bench will remain the same. I mean, better.
When will remain? You still there?
Tuesday. Okay. Very well.
This is the matter on Tuesday.
My lord will keep it as a part of matter.
You mentioned it because it's just starting. We don't want to keep it status. Just thank you.